Real property, the rights and duties of landlords and tenants. There are three basic forms of lease or tenancy. A fixed-term tenancy lasts for a fixed term and automatically terminates on expiration of that period of time. A tenancy at will continues as long as the will of the landlord and tenant allow, so it continues until terminated by one or both of the parties. A periodic tenancy is most common and lasts for a period of time. A month-to-month lease is a periodic estate. Of course, it could be week-to-week or year-to-year. These are all periodic tenancies. If there's no agreement otherwise, and the court is looking to discover what form of tenancy applies in a case, the court will hold it to be a periodic month-to-month tenancy if the rents are paid on a monthly basis. A tenancy at sufferance arises when a person in rightful possession of land wrongfully continues in possession after the right to possession ends. Most authorities agree that this is not technically an estate in land, but rather a convenient label. The landlord is free to evict the purported tenant at any time. The landlord has a number of duties with respect to the tenant. Firstly, the landlord has a duty to provide possession to the tenant and remove holdover tenants where necessary. This English rule is now the majority rule in the United States. The tenant is not expected to evict prior tenants to gain possession. This is the duty of the landlord. The tenant has a right to quiet enjoyment of the property. Although it may not be written into the lease, a covenant of quiet enjoyment is implied in all landlord-tenant arrangements. So the landlord has a duty to allow the tenant quiet enjoyment, and this means he cannot deprive the tenant of access to the lease space or otherwise interfere with the tenant's use of the property. If the landlord wishes to remove the tenant, he has to go through the courts. Illegally removing the tenant from the property through eviction would breach the implied covenant of quiet enjoyment. This covenant also implies that the landlord has the right to lease to the tenant. If the landlord is an impostor, he is breaching the implied covenant, as he is not in a position to provide the tenant with quiet enjoyment of the property. It's public policy to protect the interests of tenants in residential property, and there's now an implied warranty of habitability incorporated into residential leases. Businesses entering into commercial leases are deemed capable of looking after themselves. So these housing codes only apply to residential properties. The local housing codes are often used to set the standard of care required, and a material breach of the housing code can lead to a citation from the local authorities as well as a private action from the tenants. The duty to maintain the property in a fit and habitable condition is placed on the landlord. The landlord is responsible for keeping the property up to the standards of the local housing codes, making repairs, and ensuring that the shared services such as electrics, plumbing, elevators and so on are properly maintained. Where the failure to meet the standard is the fault of the tenant can be held directly responsible, or alternatively, the landlord can be held responsible but able to claim compensation from the tenant. The landlord has only two rights: the rent and reversion. The reversion is, of course, a future interest, allowing the landlord to possess the property when the tenant moves out. Often the duties of the tenant are spelled out in the lease, but some are implied in law. Of course, the first duty of the tenant is to pay rent. The tenant also has a duty to avoid waste. This means avoid damage to the property. Although most of the duty of repair is on the landlord, under the implied warranty of habitability, the tenant does have a duty to repair as necessary to avoid damage, waste. This does not apply to regular wear and tear, but to extraordinary situations such as a flood, where a reasonable tenant would undertake a repair to prevent harm to the property. The tenant has a duty not to create a nuisance or disturb neighbours, and to refrain from using the property for an illegal purpose, like gambling in a state where gambling is unlawful. The law governing the duty to maintain the condition of leased residential premises has changed dramatically over the last 30 years in response to the problem of substandard housing. The common law tended to impose the duty to repair on the tenant. This is still the case in most commercial leases, where the tenant is a business. It would be, and is, unfair for the landlord to rent the property to the tenant. Then a condition arises that the landlord was unaware of, injury results, and the landlord is then held liable. In this situation, the landlord is not liable. There's no way the landlord could have fixed the problem or prevented injury, as there was no way he could have known about it. However, in residential leases, the landlord is now held responsible for personal injury sustained as a result of conditions on the leased property under certain situations. If the landlord agrees the lease should contain a covenant to repair, then he is liable for repairs, and accidents and injuries resulting from lack of repair result in the landlord being held responsible. When the landlord undertakes a repair, with or without the covenant in the lease, the landlord has a duty to carry out the work to a reasonable care standard. The landlord is liable for his own negligent repair attempts. If the injury was caused by a defect that was not obvious to the tenant, the landlord is generally held liable. The landlord has a duty to inspect the property before handing possession to the tenant, so the landlord should be on notice of these latent defects. The landlord is also held responsible for injuries caused in common areas such as stairwells and corridors. These are areas shared by multiple tenants and under the control of the landlord. Along these lines, the landlord has a duty to maintain security features and standards. If the security cameras were operational when the tenant leased the property, but they were not maintained, and the tenant is robbed or attacked as a result, the landlord is held liable. If the cameras have never worked, and the tenant was aware of this, the landlord is relieved of liability. Housing codes are increasingly being used to set the standard of care of the landlord under the theory of negligence per se. If the housing code requires window locks that the landlord fails to fit, the landlord can be forced to pay for resulting thefts and injuries under the doctrine of negligence per se. Landlords have a heightened responsibility for defects on vacation apartments and other forms of short-term furnished residential lets. Vacationers don't have time to inspect the property for dangerous conditions when they rent by the day or week, so the landlord is held liable. When a property is leased for public use, such as a store or restaurant property, the landlord is liable for injuries caused to the public by dangerous conditions on the property. The tenant can bring a lawsuit if the landlord breaches his duties, but only after providing the landlord with notification and a reasonable time to cure. The cause of action will usually be a breach of the implied covenant of quiet enjoyment in a commercial lease, and a breach of the implied warranty of habitability in a residential lease. The remedies available in court would be unlikely to include specific performance. The court does not want to spend its time monitoring the maintenance work of landlords, so this is not an available remedy. Of course, the tenant can terminate the lease and leave the property. She can also claim an abatement, a reduction in rent. In some situations, the tenant can undertake repairs herself and deduct the costs from the rent. Damages are available to compensate the tenant for the costs resulting from the landlord's breach. Damages could include a refund of rents paid and compensation for damage to personal property. Where medical injury is involved, the tenant can claim for medical expenses and pain and suffering. Claims of mental distress are sometimes considered by the modern courts. In a periodic tenancy, the general rule, and the rule that applies to most landlords and tenants, is that the notice required is one full period. So 1 week's notice is required for week-to-week tenancy, and 1 month's notice is required for month-to-month tenancy. There is an exception. Long-term periods, 6 months' notice is considered sufficient for year-to-year tenancy. The question often arises as to when the period starts, and the answer depends on the lease. If the lease is structured so payment is required on the first day of each calendar month, this is when the period starts. So if notice is given on the 15th of June, the notice is effective July the 1st, and then tenancy expires just before the clock ticks over for the 1st of August. Where the landlord and tenant mutually agree to terminate the lease early, the tenant is said to surrender her rights to the landlord. The merger of the tenant's rights and the landlord's rights result in a fee simple absolute held by the landlord. When the tenant cannot reach agreement with the landlord for early termination of the lease, the tenant sometimes walks away. This is known as abandonment by the tenant. The question before the court is often what the landlord is able to claim as compensation for the tenant's breach of duties. The old rule was that the landlord could simply leave the property empty and claim full rents from the tenant. The new rule says that the landlord has a duty to mitigate his losses. The landlord has a duty to make reasonable efforts to find a new tenant, and the tenant is expected to compensate the landlord for only his resulting losses. When calculating the tenant's liabilities resulting from abandonment, the court assesses the landlord's losses by deducting the fair market value of the rent the landlord is able to generate from reletting the property from the rent contracted by the abandoning tenant. This is assessed for the period that the landlord is out of pocket as a result of the abandonment, and future losses are discounted to bring them to net present value. The landlord is able to recover the expense of reletting, including agents' fees, advertising costs, etc., and is able to recover the full rent during the vacancy period, when the reletting activities are taking place. The tenant is required by the court to compensate the landlord for losses resulting from abandonment, but the landlord has a duty to relet and mitigate the costs. If the lease terminates, but the tenant remains in the property, he is known as a holdover tenant. The landlord has several options. The landlord will likely wish to change the locks and throw the tenant's belongings out of the property. But this form of self-help is illegal today and frowned upon by the courts. The quickest way of evicting the tenant is to initiate unlawful detainer proceedings in court. Or the landlord can initiate a periodic tenancy. The determination of the period, perhaps year to year or month to month, depends on the prior tenancy. If the fixed term lease was for more than 1 year, then the periodic tenancy is often deemed to be year to year. This can be fruitful for the landlord, as the holdover tenant is required to pay a full year's lease. If the expired lease was less than 1 year, then the new lease is deemed to be month to month. When the tenant initially rents the property and subsequently buys it from the landlord before the lease is up, the tenant's rights are effectively merged with the rights to rents and the reversion that were held by the landlord. The tenant becomes her own landlord and gets a fee simple absolute. The transfer from the landlord to the tenant is referred to as a release, as the landlord releases his rights to the tenant. The result is known as a merger, as the rights of the tenant and those of the landlord are merged into a fee simple absolute. If the property is destroyed by disaster, fire, or other causes before the tenant is able to take possession, but after the lease is agreed, we have an interesting situation. What happens to the tenants and landlords' duties to each other? Well, the tenant has the option to terminate the lease if the tenant is one of many in the same property. But if the tenant leases the whole property, the courts are less sympathetic and expect the tenant to insure against such loss. Another question that arises is whether the tenant can force the landlord to rebuild. The answer is no. The landlord does not have to rebuild unless it was contractually agreed between the parties or the destruction was due to a breach of the housing code in a residential lease. A tenant may wish to transfer the lease to another tenant. A transfer of all rights is known as an assignment. A transfer of less than the lease rights held by the tenant is a sublease. If there are 365 days to run on the lease, and the tenant transfers 364 days, this is a sublease. An assignment would require transfer of all 365 days outstanding. The original tenant is not released of liabilities to the landlord by assignment or sublease, but the new tenant can become liable to the landlord as well. Unless the new tenant agrees with the original tenant to assume the rent or other liabilities to the landlord, the new tenant can, however, release his liabilities to the landlord by reassigning the lease to yet another tenant. An original tenant, having made promises to the landlord, covenants, can only transfer these obligations to the new tenant when the covenants touch and concern the land. They involve the real estate, and the transfer is a full assignment as opposed to a sublease. The old tenant retains all the duties to the landlord when entering into a sublease. The new tenant can agree to assume any covenants of the old tenant under the sublease, but this needs to be explicitly agreed between the old tenant and the new tenant in the sublease agreement. If the tenant transfers with the landlord's consent, there's no dispute for the court to consider. The questions that come before the court often involve assignments and subleases by tenants without the landlord's consent. Public policy supports the free transfer of real property rights in the United States, and restrictions on transfer, known as restraints on alienation, are not supported. So when a tenant assigns or subleases her rights, the transfer is valid, it's not void, regardless of whether the transfer violates provisions in the lease. The transfer can form a breach of the lease contract, and this can lead to remedies for the landlord that include damages and lease termination. Many leases require the consent of the landlord, but state that such consent will not be unreasonably withheld. This is interpreted by the courts to allow the landlord to withhold consent for valid reasons that affect the landlords or other tenants. The landlord can refuse consent for transfers to new tenants that change the use of the property, interfere with the rights of the tenants, the other tenants, or have poor credit ratings. The courts do not view a demand for an increase in rent from the landlord as a reasonable reason for withholding consent to a transfer. In the lease arrangements, the landlord holds rights to rents and reversions. The original landlord can sell or otherwise transfer these rights to the new landlord. The duties of the tenant to pay rent then shift from the original landlord to the new landlord. The original landlord is not released of his obligations to the tenant, the covenants, when he assigns to the new landlord and the covenants touch and concern the land. The tenant can hold the new landlord and the old landlord liable for these covenants. A promise by the original landlord to refund security deposits when the lease is up and the tenant leaves is not treated as touching and concerning the land. So the tenant has to pay rents to the new landlord, but can't look to the new landlord for a refund of security deposits paid to the original landlord.